there, I'm Hilary Clark. I'm one of the producers with The Agenda with Steve Paikin on TVO. And last spring, Citizenship and Immigration Minister Jason Kenney introduced what he called transformative change to the immigration system. And one of the elements of that transformation was the elimination of a backlog of applications under the Federal Skilled Workers Program. Anyone between, I think it was up till February 27, 2008, their applications were slated to be returned to them. So today I'm joined by Bellissimo, who is a Toronto immigration lawyer with the Bellissimo Law Group and Vice Chair of the Canadian Bar Association's National Immigration Law Section, to talk about that program and the backlog and particularly where that is right now. So hi, Mario. Thank you so much for joining us.
Good afternoon, Hilary.
We're going to start just for people who don't know anything about this. Could you start just by giving us a general overview of what the Federal Skilled Workers Program was and why there was a backlog?
Okay, so Federal Skilled Workers are applicants that apply to Canada in an economic class, and they have to score 67 points out of about 100 points to qualify for migration to Canada. It's based on age, education, adaptability, work experience, and by the time, usually you're looking at a good 100,000 applicants per year in this category, sometimes less, 60 to 70,000, and they are allowed to bring along their spouse and children, and those are referred to as dependents.
And they're applying for permanent resident status leading to citizenship, is that right?
Correct, yes.
Okay. And so why was there a backlog?
So many things contributed to the backlog, including processing priorities, targets, sheer volume of applicants, and by the time that they considered terminating the backlog, we were looking at about 98,000 principal applicants and about 300,000 people in the backlog of applicants that have applied before February 27th, 2008, because there's also an additional backlog for applicants that have applied in a new category, still the Federal Skilled Worker category, but after 2008 it was prioritized more by a restricted list of occupations as opposed to the more broad-based occupation model that we saw before 2008.
Okay, so and what's the status of, the announcement was we're going to just send these applications back. Is that what has happened with that backlog? And maybe if we could just be clear, it's from 2004 to 2008 is roughly the period we're talking about?
Yes, the longest standing, because they continued processing these until June 29, 2012, when this became law, Bill C-38. So at that time, we were looking at applicants from 2004 between 2008, and so yes, the oldest inventory is from 2004.
Okay, and so now so the announcement or the policy change that was in the budget bill, C-38 that you mentioned, was that they were just going to send these back. They would refund the fees that people had paid, and they were welcome to reapply if they wanted under the new categories and so forth, but that process was going to be terminated for them. Has that actually happened?
So what happened is before the law came into effect, lawyers and applicants began to understand what might be happening, and some applicants were obviously facing an inordinate delay, so they began proceedings in the federal court to compel a decision. And then once it became law, many applicants then chose to challenge the new law based on constitutional factors and other legal arguments. So what ended up happening is between June 29th and roughly late November, there was a negotiated stay between the Department of Justice and the applicants that have challenged the law. So there was no refunds or terminations that occurred in that time. Since then, they have begun terminating and refunding files, although the litigation continues.
Okay, so now when they refund, for the ones that they have refunded, they're refunding the application fees and so forth. Is that usually the bulk of the cost of an application under immigration, or are there other fees that might might be involved, I don't know, translation or something of documents. What I'm getting at is refunding the fees doing, you know, does that really give us a good picture of refunding their effort, if you know what I mean?
Yes, basically $550 is the application fee for a principal applicant, and then there's dependent fees as well for every adult applicant. It's another $550. So it is a portion of what they obviously expend on this, but there's also medical checks, criminal checks, as you indicated, language testing, also if they have representation, travel to get to and from you know, potential doctors or interviews or to source out documents. So it's not unlikely that an applicant would be in the thousands of dollars in pursuing permanent residency to Canada.
Okay, and do we have a sense of who was in this backlog? I mean, do we have, are these, you know, engineers from one country more than another, or is it sort of just a broad swath of the kind of people who apply to Canada, which is, you know, from all over the world?
Well, part of the challenge that we have currently before the court is we felt that there's been discriminate processing based on the part of the world that you either reside or is your national origin. And at the time of the backlog in first instance, which would have been 2008, if I might just quickly refer to some statistics, there was about 230,000 applicants in the backlog, and at that time, about 66% were from Africa, Middle East, and Asia in terms of volume, and 33% were from Europe and the Americas. And that was in 2008. At the time of termination, we are looking at 92% being from Africa, Middle East, and Asia, and about 8% from Europe and Americas. Now, these are statistics that we compiled. The government does not necessarily agree with that breakdown. Their breakdown is more in line of 82% from Africa, Middle East, and Asia, and about 19% from Europe and the Americas. But in either case, the actual terminated files don't necessarily reflect the volume at the time of backlog at first instance.
Okay, so give me a sense, if you can, could you give me a sense of, I know that there's a number of legal challenges in process. I think there was a movement to certify a class action. There's a number of things that were just heard in January, as I understand it. Can you give us an overview of the kind of challenges that the government's facing in the courts on this?
So they're facing constitutional challenges, which means in our case we're trying to strike down the law, because when the backlog began and they finally reduced it, by the time reduced it by about 51% by the time they terminated files, our argument is that there's been discriminate processing during that time, and therefore other people have been disadvantaged because of that. It wasn't by volume, and it was by country of residence. Other people are challenging, that's under Section 15 of the Charter, other people are challenging the right to life, liberty, and security of the person under Section 7, the ability to be able to sponsor someone, to be able to bring your spouse to Canada in terms of if she's a dependent on your federal skilled worker application. Other people are challenging it based on the rule of law, that this has a retroactive application that is unfair. Other people are arguing that Section 25, which is humanitarian and compassionate consideration, should have been offered to applicants before they were terminated. So a number of procedural fairness arguments are being advanced. And we learned just today that the decision is likely to come out towards the end of this month from the Honorable Justice Rennie. Okay.
I mean, there's so many things there that you laid out. I'd love to follow up on every one of them, but we don't have that kind of time, unfortunately. Let me ask you, though, are there precedent? I mean, I think, are there precedents in other jurisdictions or in this country or in other countries where a court has, where the courts have said that foreign nationals have an ability to force, like the Canadian government's hand on this issue? I mean, obviously, you're hoping for some remedy for your clients. Are there precedents where the court says the government owes foreign nationals something?
Well, it's an interesting question. Part of this termination was attempted in New Zealand and met with differing results, but there is actually no precedent because there's not a Charter of Rights and Freedoms and the constitutional structure that we have in Canada. So technically there is not a precedent because this is an unprecedented move in immigration history. So we are somewhat in uncharted waters, although the parties, that being the Department of Justice as well as applicants' counsel, have all agreed in their submissions to the court that the Charter does apply to these foreign nationals because they are necessarily under the actions of Canadian legislation, Canadian authorities in carrying out their duties, and therefore it necessarily falls under Canadian law.
So what are you hoping the court will do?
We're hoping that the court will strike down the law as unconstitutional and that these applicants are processed. Our argument was that at the time in 2011, when they first began backlog reduction between 2008 and 2011, the government was actually 2 years ahead of schedule. They were doing a great job in reducing this backlog, and it seems somewhat arbitrary to all of a sudden decide to stop that backlog reduction at 51–52%, and then somehow suggest that an applicant who's processed on June 28th, 2012 is worthy of economic migration to Canada, but as of July 1st, 2012, they're not worthy. So this type of arbitrary distinction is problematic for us as counsel. It's also problematic for me just as a Canadian. I think it's unfair. These people have lined up for many years. They've patiently waited, and I think they're entitled not to the right to migrate to Canada, but to the right to have a decision on their application.
Okay. I'll just ask you one more question, and that is, as I said off the top, the reforms were meant to sort of transform the whole immigration system, and in particular to make the federal skilled workers program work better, be more efficient. And I understand the objections, that you're representing on behalf of your clients, and as you just said, that you see that it's the way this has been handled isn't the way you'd like to see it handled. But do you think, as an immigration lawyer, that the plan going forward will actually improve the system? And maybe in that you could also tell us the state of that program, the Federal Skilled Workers Program, right now.
Well, the Federal Skilled Worker Program is scheduled to reopen, because right now it's on a pause, scheduled to reopen in May, and the hope is that we could have a just-in-time system, so where we see processing in under 6 months or around 6 months. And of course, anybody would want to see that kind of just-in-time and an effective system. Nobody wants applicants waiting years and years, and that's not a good reflection on Canada either. The problem I have at this point is that we are moving forward with a new program while we still have unfinished business with this backlog. And I think it's going to be challenging, even if the decision goes in favor of the government at this time, there will still be individual applicants that will challenge. It will likely go to the Federal Court of Appeal. There will be many issues that will continue to flow from this action taken, which I think will impact any new program. So it would have been my hope to process the backlog or create a clearer time in which certain categories might not be processed. But again, none of that has been explored at this point. We are where we are, and we are concerned about what this means for the future.
Okay. Thank you very much. It's really, really, really informative. I really appreciate your time, and thank you for joining us today.
My pleasure. Thank you for having me.